In a unanimous decision, the U.S. Supreme Court has sided with Oklahoma in a case against the Tarrant Regional Water District. The Texas Water District sought to acquire water from Oklahoma, citing a water compact signed between states along the Red River. While this case is settled, the decision could have a ripple effect on other legal battles over water. I spoke with Marguerite Chapman, Professor Emeritus of Law at the University of Tulsa, about it. Professor Chapman, the U.S. Supreme Court ruled unanimously in favor of Oklahoma. Were you surprised by the decisiveness of the decision?
Yes, actually I was. I had predicted to some colleagues that I thought it would be 7-2 or possibly 6-3 in favor of Oklahoma. Chief Justice Roberts asked some questions during oral arguments back in April that made my heart skip a bit and made me a little bit concerned about which way he would go, as did one other justice. And so unanimous ruling was a surprise. I thought it would go for Oklahoma, but not unanimously.
What was the court's rationale in siding with Oklahoma?
Well, Justice Sotomayor looked at three different factors. First, she said a guiding principle is the principle of state sovereignty, states' rights, and that states do not easily or readily give up their rights to other states, even in negotiating an interstate compact. And secondly, she said, let's look to the language of other compacts. And what does that language have to say with regard to cross-border rights of one state to go across the border into another state and divert water for that other state? And then thirdly, she looked at the pattern of conduct between Texas and Oklahoma during the 27 years that ensued from 1980, when President Carter signed the federal legislation approving this compact, and continuing until 2007, when Texas filed the lawsuit trying to divert water from the Red River Basin in Oklahoma.
You were involved in a friend of the court brief in this case.
Yes, I was. And the friend of the court brief particularly went to two aspects of the lawsuit. One, the point that states do not easily give up their states' rights over water and other natural resources within their borders. And secondly, the point involving other compacts that allow diversions from one state into the other state do so expressly. And if you look at the language, and Justice Sotomayor cited to these other compacts, as we did in our friend of the court brief, you'll see that there is very specific language addressing the point of whether Arkansas, for example, would have the right to come into Oklahoma and get our water, or Kansas would have the right to come into Oklahoma and get the water from the Arkansas River. And there are many other compacts that have language that address the how, whether a diversion is allowed whether one state can cross into another state and divert water, what triggers it, whether there are eminent domain rights accorded to the other state, whether storage facilities can be built by one state on the property of another state. And these provisions are not in the Red River Compact. And you go back to the earlier point that states do not easily give up their states' rights. They do not easily cede their sovereignty to other states. One cannot read silence in the Red River Compact to find that there's some sort of right for Texas to come into Oklahoma and divert water from the portion of the Red River Basin that lies within the jurisdiction of Oklahoma.
So this will have a major impact on water rights cases going forward, and we're glad you could explain it to us. Marguerite Chapman from the University of Tulsa, thanks for joining us.
Thank you.